versus Jocelyn Benson in her official capacity as Secretary of State. It is a Court of Claims case 20-225, and we are ready to proceed. If you would invite the litigants into the hearing room. If you are speaking, I cannot hear anything. I can still hear nothing if you are speaking to me. Okay, I hear a buzz. Does anyone else hear it?
I hear it as well.
I don't know what its source is. Okay. There are only, why don't we try this? Then what the source is. Okay. Mr. Hearn, it appears that when you unmute, we get the sound. So unmute again. Mr. Thorne. We cannot hear you, but we could in fact hear the awful sound. We cannot hear, we cannot understand a word you are saying, sir. Do you want to go out for 5 minutes and attempt to, well, I guess he did. Mr. Hearn, perhaps you need to try another piece of equipment. Mr. Hearn. Mr. Hearn, perhaps you just need to be visual for a moment while I give you a secondary instruction, because we are not going to be able to hear anything that you are saying. Mr. Hearn, it appears that there is a substantial difficulty. And okay, I see two of you. I don't quite know why. I can't hear either of you. The one I can see I see one with a backdrop and it had no sound. Now I see Mr. Hearn behind the green screen. Can you speak now and let's see what we hear?
Yes, we brought in another laptop, Your Honor. Are you able to hear us now?
Yes, that was what I was trying to say before, get another piece of equipment, but okay.
Thank you, Your Honor. Sorry about those technical issues.
Okay, this is case 20-000225MZ, Donald J. Trump for President, Inc., and Eric Ostergen versus Jocelyn Benson in her official capacity as Secretary of State. I would like to at least make an initial apology. Emergency matters usually emerge in the middle of other matters. That's their nature. So yesterday at 4 o'clock, this matter was filed with the Court of Claims. At the time that it was filed, there was a complaint for immediate declaratory relief filed. While it was a verified complaint, it did not have an affidavit affixed to it. It did not, at that point in time, have a request for a temporary restraining order without notice attached to it. It did not have a request for injunctive relief attached to it. Later in the evening, the Democratic National Committee, after hours, filed a petition to intervene. This morning, sometime around 9 o'clock, yes, a set of supplemental papers were filed on behalf of the plaintiff, the first of which was something that addressed supplemental evidence, it said, and it was an affidavit from a Ms., I'm going to mispronounce her name, but a Miss C. Additionally, there was a petition filed for injunctive relief. The court determined, even without a proof of service, that because of the nature of the proceeding, that I needed to put it in the middle of our case call, and that we would let parties come forward and say what they needed to say in as quick a manner as we could. The court has not ruled on the petition to intervene filed on behalf of the Democratic Party, but did afford them the opportunity to file papers as if they were an amici, while the court made a determination of any standing and whether or not intervention would be granted. With that, the court set a hearing for 11:30, thinking that my morning call for the Court of Claims, for the Court of Appeals rather, would be done by then. Unfortunately, one of my colleagues had no power, and so it took us until about 10:40 to even begin the Court of Appeals docket, and it just concluded. I am very apologetic about that and appreciative of the patience of all the parties in this case. As you can imagine, I have done a speed read of the multiple pieces of paper that were filed. The defendant did in fact file a response to the request for injunctive relief. And about 2 minutes ago, the amici filed papers, which I can earnestly tell you I have in front of me, but I have not read. The way in which I'm going to proceed today, without affording the proposed intervention, because this is going to have to be managed today and fairly quickly, I am going to give them the courtesy of brief oral comments, and I will give them that courtesy after the named parties have spoken to whatever issues they deem appropriate. Are we clear on at least how we're going to try to get through this?
We are,
With
Your
that,
Honor.
okay, with that, we begin, please, with counsel for the plaintiff.
Yes, Your Honor. Thank you. And good afternoon. From the plaintiff's perspective, what the relief we're asking this court to grant is very simple. Is simply to direct that Secretary Benson order that the election counting authorities and the counting boards that are handling ballots allow challengers who are qualified under Michigan statute to participate and to observe that process. Many of the ballots have in fact been counted. Some are still being adjudication boards are still being convened. And so the request is simply that Eric Osterden, who is a named party, as well as the Trump campaign and their designated challengers, be allowed to participate and meaningfully observe that process.
Counsel, I guess what I need to understand, in order for me to give injunctive relief, I would have to first find that there is an immediate threat of irreparable harm, and that first, that there's a substantial likelihood of success on the merits. Let's start there. And in order for me to make that determination that somehow you're being deprived of meaningful participation, I've got to make a fact finding. I looked at the affidavit repeatedly, and the affidavit appeared to say to me that there was a person who had been approached by another human being who is unnamed, but described as a participant in the counting process, and that individual who is unnamed, but a participant in the accounting process, gave information to the affiant that indicated that there was some malfeasance going forward. So what I have at best is a hearsay affidavit, I believe, that addresses a harm that would be significant, but that's what we've got. We've got an affidavit that is not firsthand knowledge. If there is something in that affidavit that would indicate that the affiant observed activity that would be a deprivation of the rights of poll watchers, I want you to please focus my attention on that.
I would indicate, Your Honor, attached to that was a note that was, again, this was a election inspector who was appointed according to the affidavit, that was handling the processing of ballots that had been sent in prior or after on November 4th, after the deadline, were noted to be a ballot that was received timely. And that
okay, so I want to make sure I'm understanding you. The affiant is not the person who's had knowledge of this. Is that correct?
The affiant had direct firsthand knowledge of the communication with the election inspector and the document they provided them. Okay,
which is generally known as hearsay, right?
I would not think that's hearsay, Your Honor. That's firsthand personal knowledge by the affiant of what she physically observed, and we included an exhibit, which is a physical copy of the note that she was provided.
And I'm going to see if I can pull up this physical copy of the note, because while I'm doing that, you can continue your argument.
Yes, Your Honor, thank you. And the gist of what we're asking both the court to do and where we have a concern is not just this specific instance But what we're asking is that the Michigan law, which election code at 168-733 has specific duties for challengers who are able to observe the processing of ballots. And
who is it? Who has averred that they have not been given that opportunity? Did I miss that too?
That would be Eric Ostrogen, who's the plaintiff, one of the named plaintiffs, who was excluded from the Oakland County Counting Board. And so
his status, other than being a candidate, what is his status?
He is not a candidate. He is a challenger, a designated credentialed challenger, and he was removed from the counting board. And the allegation, not just that that is what he said, but then in addition to that, the Trump campaign has a right as a party and a candidate in this election to have challengers meaningfully participate. And that's what we're asking the court to direct Secretary Benson to allow. We understand.
What do you mean by meaningfully participate? What is it that you believe they have not been afforded the opportunity to do that they have a legal right to do?
Right. So I would refer the court to Michigan statute in the election code 168-733. We quote it in our brief, and it provides the rights and responsibilities of election challengers, which means they have the ability to oversee or to meaningfully observe the election inspectors processing of ballots in the conduct of the election. And that's what we're asking direction from Secretary Benson to the local counting boards, that they make sure that they comply with this. I mean, I can go through the statute. I don't want to take the court's time to read it. We quote it at page 4 of our petition.
Okay, you may proceed.
Yes, so that is the relief we're asking the court to grant, Your Honor, is an order directing Secretary Benson to allow challengers designated by, they can be Democrat or Republican, but to have meaningful opportunity to oversee and observe the conduct of the election, and not to exclude them, but allow them to see how the election inspectors are in fact processing the ballots and authenticating them and adjudicating them.
Okay, I've gone back to your affidavit, and what I have is something that says it entered receive date as of 11/2 on 11/4. And it says that this was coming, it doesn't say, it says the individual who spoke to her was a poll worker with no name. Okay.
That is correct, Your Honor. That's what but when you read the affidavit, you will see that Ms. Conaran indicated, who is in fact herself an attorney, Michigan attorney, indicated that the poll worker indicated that this was in fact she was directed to basically predate.
I understand, but I'm still trying to understand why this isn't hearsay.
Well,
I absolutely understand that it's what the affiant says she heard someone say to her, but the truth of the matter asserted therein that you're going for is that there was an illegal act occurring. Or because other than that, I don't know what its relevancy is.
Right. I would say, Your Honor, in terms of the hearsay point, this is a firsthand factual statement made by Ms. Conaran, and she has made that statement based on her own firsthand physical evidence and knowledge.
I heard somebody else say something. Tell me why that's not hearsay. Come on now.
Well, it's a firsthand statement of her physical.
It's an out of court statement offered for the truth of the matter asserted therein, right? So if the truth is that somebody told her something, not what they told her, That's one thing. You want me to find the truth, or at least a scintilla of truth, in what she says the contents of that communication were. Right?
What we're asking the court to do, Your Honor, is to, on the basis, again, it's not based on what the relief we're asking is not just based on this affidavit. The relief we're seeking the court to order Secretary Benson to direct election officials to allow observers and challengers in Michigan counting jurisdictions as provided by Michigan State Law 168.733.
And I've got to find that they're not doing that in order for me to have a basis to tell them to do that.
Right.
So you wanted me to look at the summons and the complaint, because you're telling me that in certain paragraphs of this complaint, I'm going to see that Mr. Ostergen says that he was ousted. Does he tell me the circumstances under which he was ousted? And
he was a designated qualified challenger, and he was told to leave the counting board. That's the allegation that we make. That's the statement that we make in the verified complaint.
Okay, you may proceed further.
Again, I come back, Your Honor, to what we're asking the court to do, and I know I've said it several times, but it's simply to direct Secretary Benson to have the local election counting boards provide meaningful opportunity for challengers from the Trump campaign, as well as Mr. Ostergen. And frankly, I mean, the other parties aren't parties in this litigation, but we would be fine with the Biden campaign or anybody else having challengers, as provided in Michigan law, observe the process. And that's really the relief we're requesting.
Okay. In response from the Secretary of State, I don't know who's responding, but.
Good afternoon, Your Honor. Heather Meingas on behalf of Secretary Benson, along with Assistant Attorney General Eric Grill. I guess first I would note, I know the court's aware that we filed a response. That response was to the emergency motion for declaratory judgment that we received on November 4th. We did not receive a motion for injunctive relief that was apparently or purportedly filed today sometime. So I'm not sure of what that pleading says and whether it negates some of the response that we've already provided. But so we've responded to the first motion. I don't have a second motion. And okay, I think it was
Ms. Meingas,
sorry.
What motion? There was no, the original summons and complaint didn't have a motion.
The summons and complaint that we had was accompanied by an emergency motion for declaratory relief.
What we got was, we got a summons. Okay. All right.
Okay.
So
well,
when was the request for injunctive relief served on behalf of the plaintiff?
Your Honor, if I can address that question, it was served both electronically on behalf of the plaintiffs to Secretary Benson as well as the others. And we also had a process server who tried to physically deliver it to the Secretary of State's office, but the office was closed and they could not get access. But clearly the Secretary of State has copies of all the pleadings.
I do not, Your Honor. We do not have a copy of a motion for injunctive relief. I've looked in my email. Mr. Grill has as well. If that could be resent, I'd be happy to look at it. I'm just pointing out for the record, we filed a response to the initial motion, and that's, what I can address today. And I think
I think what you're describing as the initial motion, you got pleadings in a different way than I did. I got a summons and complaint, period. Then I got additional papers this morning and a copy of a proof of service later this morning. I think that we're substantively talking about the same thing. They just came in pieces.
That could be, Your Honor, and I don't know that it makes any difference. I mean, our arguments wouldn't really be any different in the second motion if it was an motion for injunctive relief. I mean, as we set out in our response, there are numerous defects and problems with the pleadings that have been filed in this case. And most significantly here, there really isn't any relief that can be granted at this time. As set forth in declaration from Director Rader, the counting boards are done. We have finished counting AV ballots in Michigan. And so there isn't any, there are no more counting boards functioning as far as challengers and precinct inspectors, reviewing AV ballots and processing right now. That those functions are complete, at least as of this morning from Director Rader. And so to the extent that the plaintiffs are requesting that we halt, the processing of AV ballots so that somehow challengers can have some sort of opportunity to review the process, there isn't any more opportunity to do so because the counting boards have completed their functions. So the ship has really sailed on the relief that they're requesting in this case. I think so. We pointed that out through our latches argument to some extent, and also really now what we're talking about is sort of a mootness argument. And I'm also a little bit confused today as to their argument about with respect to the challengers. If you look at their pleadings, the basis of their pleadings is that the challengers were being denied an opportunity to review surveillance video of the drop boxes. That is the basis of their complaint and the emergency motion that we read. So this opportunity for a meaningful review as pled in the pleadings is that they wanted some sort of opportunity to review surveillance video of drop boxes. And so that's how we've addressed our pleadings, our response, because that's how it was pled. I didn't hear any of that today.
Additionally, Ms. Meingas, they did say in the second paragraph that the named plaintiff was removed.
Right, but if you look, that's why their pleadings are confusing, because their pleadings talk about election inspectors of both parties not being present for various aspects of the counting board process. Mr. Ostergren is not an election inspector, he's a challenger. And so there is some, to me, we're at 6s and 7s with respect to what the pleadings are actually saying and what kind of is really going on or what the law is. And Mr. Ostergren doesn't explain where he was excluded from, which AV counting board, what day that happened, why he was excluded. And that doesn't even really feed into his exclusion for whatever reason, doesn't feed into the claims that they've pled, which where their arguments are that election inspectors from both parties are not always present at the counting boards to review the process. That's what their claim is, and that challengers are not having an opportunity to review surveillance video. So I'm just going on what the pleadings say, Your Honor, is the source of their alleged injury. And it's not really kind of matching up with the argument that we're hearing from counsel this morning. And again, at this point, it's all really moot because the counting boards are complete. We've moved on to the sort of the second phase, and all of the unofficial results and all the poll books and all the ballots and all that will be moving on to the county canvas for the boards, the county boards to look at. So, there isn't any relief that can be given at this time with respect to, halting this process and allowing challengers more opportunity to review or to fix some alleged irregularity and not having precinct inspectors or election inspectors of both parties present for these functions. So, that's what we've principally responded in our response. They also lack standing. And then if you even get down into the merits of their claims, if you even got there really isn't anything to it because they don't have an opportunity. There is no right to review the surveillance video. And there isn't really any kind of obligation as we read the statute that somehow, an election inspector of both parties has to be present 100% of the time and 100% of the places at the absent voter counting board. So I just feel like there's a little bit of disconnect between what their pleadings actually state and some of the argument that we've heard today.
Okay. On behalf of the proposed intervener present, Amiki.
Good afternoon, Your Honor. Kevin Hamilton for the Democratic National Committee. And first, I'd like to thank Your Honor for the opportunity to appear, and I'll be brief. I believe the motion should be denied for several reasons. First, the plaintiffs have failed to establish an actual controversy under MCR 2.605, which would be necessary in order to pursue a claim, for the simple reason that the factual record before the court doesn't support the relief sought. And in any event, the claim is largely moot at this point for the reasons Ms. Mindgas just pointed out that the county counting boards are largely complete now, and so the relief is simply unavailable. On the first point, no evidence in the record would allow the court to conclude that the plaintiffs have demonstrated a likelihood of success on the merits, which, as Your Honor pointed out a moment ago, is a necessary finding in order to enter injunctive relief here. The affidavit obviously is hearsay, Your Honor, at least single hearsay, perhaps double hearsay. And that is simply insufficient under any standard to justify declaratory relief. Moreover, as we've outlined in our papers, and I know Your Honor hasn't had the chance to review those yet, they've sued the wrong defendant. The Secretary doesn't operate these counting boards. The counties do. They are created and operated by local government. Those local governments, the counties, were not named as defendants, nor could they have been before this court, whose jurisdiction is limited under MCL 600.6419. So that's obviously a problem with the relief sought. On the merits, as counsel just pointed out a moment ago, there's no right to video surveillance of voters casting ballots, whether they're casting them in person or at drop boxes. And counsel doesn't even really pretend otherwise. He cites no statute and no case law that suggests that a voter or a political party or candidate has a right to surveil or review video surveillance of voters casting ballots. And in any event, even if there were some sort of factual record, and there's not, that might support the court in finding some kind of violation of the challenger statute, Michigan law provides a remedy for that. It's a criminal penalty. The legislature thought about that. What the legislature did not provide is any sort of statutory authority for a court to conclude that some violation has occurred and therefore you should stop the count or enter some broad injunctive relief. That's just made up out of whole cloth. And again, plaintiffs don't identify any authority for that proposition at all. And, you know, that's not surprising. There just isn't any. There's a purity of elections clause claim and an equal protection claim. Neither of those find any support in the law. The Trump campaign has asserted similar equal protection claims elsewhere in the course of this campaign. They have been uniformly rejected. Trump versus Bakvar in Pennsylvania was a similar claim relating to restrictions on poll watchers and challengers. The court rejected it there for exactly the reasons that we're talking about here. The claim was based on, I'm quoting, based on a series of speculative events which falls short of the requirement to establish a concrete injury. I won't go through the other cases, Your Honor. They're cited in our brief, and we quote from them at length. So for all those reasons, Your Honor, we think the motion should be denied. It's unsupported by the factual record before the court. The only evidence that's before you is both irrelevant to the actual claims in the motion and the pleadings, as Ms. Mindgas points out, and hearsay, as Your Honor has already noted. The claims are unsupported by the law, and they name the wrong defendants. So all of this is simply an effort to stop the counting of ballots cast by Michigan voters who were fully entitled to vote and are fully entitled to have their ballots counted promptly and in accordance with Michigan law. So that there's no support for this motion, Your Honor. There's no support for this litigation. The motion should be denied and the lawsuit should be dismissed. Thank you, Your Honor.
Is there anything else you would wish to say, sir?
No, other than...
Oh, I'm sorry. I should have said on behalf of the petitioner.
Okay. Thank you, Your Honor.
On behalf of the petitioner, I did have a couple of questions. Now, it was, I think, last week, Mr. Grill, that we had a case that was filed against the Secretary of State regarding this, quote, meaningful access. Am I remembering correctly, Mr. Grill?
There was a case about challengers, Your Honor. There have been many cases.
But that was, and that one was resolved by the parties. And the question there was, to have the Secretary of State revise her instructions to the local election officials regarding issues of COVID-19. And in that case, the question was, how could the qualified challengers have meaningful access to execute their functions? And the parties entered into an agreement, and a new directive was issued by the Secretary of State to the local elected officials regarding things like distancing, etc. That was a recognition, Mr. Hearn, that while the Secretary of State has a future function in this electoral process, other than giving directive and intervening in specific circumstances where extraordinary relief is requested and warranted, that the Secretary does not conduct local elections, nor does the Secretary's office have responsibility for the initial ballot tabulation. So, and I need some help from you on how the party against whom you have filed suit is a party who has the capacity to do what you've asked, even if it is warranted.
Thank you, Your Honor. Yes, no, the Secretary Benson is Michigan's chief election official, of course, and the local election jurisdictions act under her direction. She does have the responsibility to oversee the conduct of the election. In fact, there was the Western District of Michigan federal case where they did, in fact, name Secretary Benson, and then they named a number of local election jurisdictions. And in that case, the Secretary of State responded by saying that the local election jurisdiction should not have been named, but she should just be the sole defendant. And that's, in fact, what was done. And that's.
But
really,
what was the issue there?
well,
That was your issue about, and was that your, there have been so many. And for every court of claims case, there have been 2 federal cases. So I know why Mr. Grill and Ms. Meingast are a little confused. There was a case filed in the district regarding the mailing of absentee ballot applications. There was a case filed regarding the processing of absentee ballot application signatures, and a few others. So I don't know what that Western District case was about, but every case that I have had, it has been acknowledged, and it is my understanding of the law of the state of Michigan, that while she does provide supervision in the broader sense, and she does provide direction, that it is not she who would be saying at Precinct 5, District 6, you, Mr. Challenger, you, Ms. Challenger, may be 3 feet away, 2 feet away. You may approach the poll book and take it in your hands. You may not. So I'm trying to understand this direction for meaningful access. She has issued a directive for what was described as meaningful access, which enumerated the functions of challengers and poll watchers from the statute. She's issued that.
correct.
At best, what you gave me in paragraph, Mr. Ostman says that he was in fact a credentialized official, and he says he was ousted from a polling place, but he doesn't tell me where or when or under circumstances. Your affiant says that another person came to her at a specific place, at least, and told her that there was activity going on that was inappropriate. Your pleadings spoke in significant detail about what credentialized officials were supposed to do under the statute, and speaks with great particularity about the ability to observe certain videotapes.
That
I'm in a quandary here.
Okay. Your Honor, I will try to assist and clarify the extent that there's an issue. What we're asking, and let me talk about the videotapes and the ballot boxes, those are essentially equivalent to a polling place, and the statute that was adopted by the Michigan literally last month, provides for video surveillance of those ballot boxes. The reason for that is to provide transparency of the election process. So when those ballots are authenticated and counted, that there's an opportunity to observe the casting of the ballots in these remote ballot boxes. That's the part of the complaint that asks to have challengers have access to those videotapes, the video surveillance.
So let me put a pin there. So when you were describing, quote, meaningful access, you wanted this court to ignore the fact that counting is done, but you wanted this court to order that each and every videotape be presented to or be available for challengers prior to the counting of the ballots?
That would be the request that we have, that the challengers have the opportunity to review the videotape, which is in the possession. Let me be even more precise, Your Honor. Our request is that Secretary Benson issue a directive to the election jurisdictions, making that video available so that challengers can have some transparency and observe the casting of ballots in these remote ballot drop boxes.
Okay, so
Your Honor.
Remote ballot drop boxes. So it's your contention that there was a requirement that for every drop box that there be a videotape made of that drop box. That's correct?
That's what the Michigan statute provides,
Okay.
Your Honor.
And the drop boxes were the drop boxes not placed prior to the passage of that statute?
The statute makes a distinction between drop boxes that were placed prior and drop boxes that were placed after October 1st. And so the statute requires the video surveillance of the ballot drop boxes. And that requirement becomes effective, and I would quote it to you, I just don't have it right in front of me right now. That is, I believe, October 1st and thereafter. And all we're asking is that a challenger be able to review that video for those ballots that are processed out of those video drop boxes. And then,
So just a question. As of this point, there's a drop box. Once the ballots are taken out of the drop box, are they segregated based upon which drop box they came from?
we have asked that there's other litigation by other parties that has asked that they be segregated so that you can identify what ballots came from what box, and you could tie that back to a video.
But are you saying there was a statutory requirement that they be segregated?
There's not a statutory requirement that they be segregated,
So,
but there is.
Are you alleging that there was a practice or routine where the individual local elected officials, election officials, separated the boxes based upon which drop box?
The request that we have of Secretary Benson.
That's not what I'm asking you. I'm asking you as a matter of fact, are you alleging that the individual election officials had a practice that segregated the ballots per ballot to ballot drop box?
I can't tell you, Your Honor, because there's so many election jurisdictions in Michigan, which ones did in fact do that or which ones didn't. And so I can't make a representation of the court as to what in fact each jurisdiction did do.
So we know that there were, that there were additional drop boxes added. I don't know if there were or not. And we do not know whether or not the contents of those drop boxes as of October 2nd were segregated from those contents that were there before October 1st. We just know that somehow those ballots were taken from their secure drop boxes to the local election official and at some point were processed. That's pretty much all we know, right?
That is correct, Your Honor. I would add, though,
Okay.
we also know that there was a legal requirement, and purportedly all the election officials honored that, of having video surveillance. And the reason that we think that's important is because for a challenger, for one of the parties to an election to have the kind of transparency we think elections in Michigan certainly requires elections to have that surveillance, to have the opportunity for a challenger to see that video is what we've requested. In addition to having challengers present, and this, Your Honor, goes to the theme of the whole complaint that we have filed, is just to have transparency, just to be able to have challengers do what Michigan law says, observe the casting of ballots and the counting
Okay,
process.
so I understand that you believe the casting of ballots includes the drop boxes and being able to, almost as if it were a drug deal, follow the chain of custody. Okay, I understand. What else, other than, is there something, the parties don't seem to disagree. Well, maybe they do. Ms. Meingast, do you have knowledge of drop boxes that were created post October 1?
We do not. The Secretary of State of the Bureau of Elections does not maintain or possess information about when a particular drop box was installed by a jurisdiction. So we wouldn't know whether it existed before October 1st or after October 1st necessarily.
Okay, all right. Please continue, Mr. Hearn.
Your Honor, again, I come back to my central point, and I have nothing further to really add to that. Is just the request that we have is that the challengers be able to access the process, be present in the processing of the ballots as provided in Michigan statute. And that includes, obviously, in the counting boards to be meaningfully available to observe the process. And then what we've mentioned on the drop boxes is that they would have the ability to review the video of that drop box as required, as the video was required by Michigan statute.
I'm going to assume and presume that the plaintiff's motives in filing this suit are, as they are stated, to maintain the integrity of elections. I'm similarly presuming that the respondents and the proposed intervener / amici shared those same values. The issue in front of me is whether or not I would issue extraordinary and extensive relief based upon the record before me. The record before me, at best, is an assertion that the Secretary of State has direct authority over the individual precincts and polling places, the counting process, the transport of all AV ballots, the observation process, and the counting of those ballots. It is, and that's a legal assertion. Factually, there is a claim that there has not been an opportunity to observe videotapes of certain ballot drop boxes that were created after October 1 with no note as to where they are, who created them, nor a statutory assertion that it was the duty of the Secretary of State to maintain a listing of those drop boxes so that she could actually order that the videotapes be presented if there is a legal right to do so. There is an allegation, a verified allegation by the named individual plaintiff in this case, that he, a qualified elector and credentialized poll watcher or poll official in Roscommon County, was at some point in time removed from the counting process. The circumstances unknown. There is an affidavit that an individual, I'm told a lawyer and a member of the bar, but no doubt a qualified elector of the state of Michigan, was approached by another human being who was purported to be a poll worker. And that human being told her that someone else told that poll worker to alter a date of receipt of a ballot from the day after the election to the day before the election, and that this occurred on November 4th. The request for relief, as I understand it, is going to be denied in a written order, which will not come out today, but an order which will indicate that the bases for denial are these. First, that the Secretary of State, as the supervisor of elections, provides direction to the local officials as to how they can comply with the laws of the state of Michigan. She has issued such directives, particularly one in a case before me, which the number of which I will list later, which indicated that meaningful access and an outline of each of the obligations and opportunities and responsibilities of poll watchers was elucidated, and that she has told the local elected officials to give people that access. Access to videotapes was not a part of the access that was addressed there because they were dealing with active polling places. I will acknowledge that. In this instance, where the issue is the day-to-day conduct of a vote count, the individuals who bear that responsibility, absent the Secretary of State removing them from their responsibility because of misfeasance or malfeasance, lies with the local election officials. So the relief that is being requested in substantial part is completely unavailable through the Secretary of State. Additionally, even if this relief were available, as opposed to when this suit was announced yesterday morning and the count was beginning, it was filed at 4 o'clock, at which point the count had largely proceeded, I am told. But as of this point, the essence of the count is completed, and the relief requested, other than the relief to observe the videotapes, is completely unavailable. The court would finally find that as to the one issue for which relief is arguably available, that on this factual record, I have no basis to find that there's a substantial likelihood of success on the merits as relates to this defendant. Nor am I convinced that there is a clear legal duty on the part of anyone who is properly before this court to manage this issue. I will endeavor to get an order out no later than tomorrow afternoon, but I have both an afternoon Court of Appeals case call and a full case call tomorrow morning. With that, I would thank you all for your presentations and would adjourn this matter where I believe everyone here at their best seeks to have a full and fair election process. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.